Welcome, 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 welcome. Welcome to the show. I'm your host, Daniel, and today is Judge O'Donnell, John O'Donnell's court docket. So, without any further ado, we're going to get started with this. Let me share my screen. Of course, I'll be watching, but I'll be muted.
Hard times.
At least it's,
Yeah, it's easy.
When were you supposed to work in the last 4 days?
Tuesday, Wednesday, and maybe today.
Do they
Might
know
have
where
to
you
work.
are?
Huh?
Do they know where you are?
Yes.
Did you get your license yet?
Not yet.
Why not?
I asked my mom to put me on her SR22 bond, and she told me to wait till the beginning of this year till her insurance restarted for the whole 6 months. So that's what I was waiting for. Because it was cheaper to go on hers instead of getting my own and paying. I have to pay like $400 a month. I'll pay like $234 or something, $243. I think she said it was a month for me to be added on there.
Oof. How much money you make at your job?
I'll be making I'll be salary now, so I think he said $13.50 every 2 weeks
Okay.
since I'll be salary.
Stop spending money on cocaine. You'll have money for insurance.
Yes, sir.
All right, I'm going to keep you on community control. 4 days, credit for 4. An IOP with Lake Geogga and follow all the recommendations and everything else I told you to do back on August 20th.
Okay.
Now, get your ass out of jail, get back to work, and meet your obligations
All right. Thank you, sir.
without the cocaine.
I will. Thank you.
All right.
That'll take you 1 to 2 hours.
All right.
Do you want to see them today?
I know. I come right through.
Come see me as soon as you. Speech pattern. It sounds like a
Feeling in my right arm is starting to come back now.
All right, how does it affect your capacity to understand things and process your thoughts?
I talked to my wife about my 2 children, and I don't remember very much about them.
Okay.
But, I don't want to roll this on as long as you guys don't either. I want to just get it over with as soon as possible.
All right. Do you, there are two counts against you of both felony 5 aggravated possession of drugs. It come from February 11th of last year. Do you remember those offenses?
From what I've been reading about it, yes.
Do you remember them independently of reading about them?
Do you remember them independently from reading about them?
Okay.
Do you remember them without reading about it?
Just
To be honest, Do you remember the offenses? Would you remember them if you hadn't read about them?
No.
How long has he been in jail? Since,
I don't remember. I got here like 3 or 4 months ago.
okay, so you were in Lorraine Correctional then, right?
You were in correctional.
Yes.
Okay. How long is your sentence there?
I go home in May, don't I?
Mm-hmm.
I go home in May, sir.
Okay.
I think it's the end of May sometime.
When did he get there? Do you know?
To Lorraine Correctional? No, I do not know.
I presume it was sometime after February 11th.
Correct. I believe that he was violated by the parole board based on this, well, not even on this case, a separate issue.
Do you know?
And we conveyed him here for arraignment.
I don't know the exact date, Your Honor. I know he was sentenced to 9 months.
On a violation?
On a violation not pertaining to this case, a different violation.
Oh, okay.
I've been trying to contact his parole officer to get the exact violation. I've not had any success.
All right.
I took.
Are you having overall problems with your memory or not?
That's what my biggest issue is, they're saying.
When's the last time you saw a doctor about this condition?
According to, that's what my issue is with the jail right now. I just went to see the doctor in the jail, I think I told you or my wife. Last week, I went and seen the doctor, and she told me I won't be on the list to go out and see a specialist for 2 or 3 months from now.
Are you going to file a motion to deal with the competency? Because it seems to me that if he's representing to me right now that he's got memory problems to the extent he doesn't know his kids' names, that would be an issue of whether he could, and he doesn't have independent recollection of the offenses. If that's accurate, then that would indicate that he may not have the ability to assist in his defense.
Yes, that was the plan, Your Honor. I just was waiting to see what was happening today prior to filing that competency, but I will get it filed today.
Go ahead.
I understand. I don't want to be in here no more.
Okay. Well,
I'll accept what you give me. I don't want to be here no more.
well, I can't give you anything until I find out if you're even competent at this point because of the stroke. So get that filed. We'll try to move this as quickly as we can to make a determination to resolve this thing. Anything else from the state?
Nothing further, Your Honor.
Okay, Nicole or Nicolette, get that thing filed, okay?
Yep, I will. Thank you.
All right.
Rise.
Here, I have received the waiver of indictment. I witnessed the defendant sign the document in open court. His counsel signed it, and I have signed it.
All right, I'll accept the waiver of indictment. Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk some more to Ms. Novotny, let me know and I'll give you more time. Do you understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have a constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
Nope.
You still want to plead guilty to this charge?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time. I could sentence you to prison, to jail, or to community control.
Yes.
Violating a protection order is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Are you presently on post-release control to the parole authority?
No.
Do you understand that if a prison term is imposed in this case, you may have to serve a period of post-release control as part of the sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. You understand that?
Yes.
If that violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence would be the greater of 12 months at the time left under post-release control. Do you understand that?
Yes.
You understand if a prison term is imposed, you are eligible for judicial release.
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. You understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
Nope.
Has anybody promised you what I will sentence you to? Do not have to follow the sentencing recommendation of either the prosecutor or your lawyer.
Yes.
Have you had enough time to talk to Ms. Novotny before pleading guilty to everything about your case and answered all of your questions?
Yes.
Have you?
Yes.
Have you been threatened or coerced in any way to plead guilty, knowingly and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
Nope.
Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on December 10th of 2025, shortly after 2 a.m., Wickliffe Police Department officers were dispatched to the Plaza Motel on Euclid Avenue in Wickliffe, Lake County, Ohio, to speak with Jennifer Chinchar regarding a protection order she had against Christopher Hensley, the defendant. On December 2nd of 2025, Ms. Chinchar had filed for and was granted an ex parte civil stalking protection order under Revised Code 2903.214 in Lake County Court of Common Pleas 25 CS 002232. Defendant was served with that ex parte protection order as well as with the final hearing date. He was served on December 3rd of 2025 by personal service. The final hearing was scheduled for December 9th of 2025. It did go forward. The defendant did not appear. The protection order was granted on December 10th of 2025 to be in place for a year. When the officers arrived on December 10th, 2025 and spoke with Jennifer Chinchar, they learned that the defendant had been calling and texting her since about 1:40 a.m. He was calling and texting, requesting information about whether she went to court that day or not, which was regarding the final hearing of the protection order. She either spoke to him or he left voice messages, so she was able to hear that it was in fact his voice, as well as he was referring to something he would specifically know. While the officers were there, the defendant called. Ms. Chinchar answered the call on speakerphone so that the officers could hear. He identified himself, indicating that it was in fact Chris, and he was asking her about if she went to court. She indicated, as well as law enforcement, that he is not to be in contact with her. These calls were about 10 texts and 6 calls from between 1:40 a.m. and 3:08 p.m. throughout the day, even after the police left. The defendant does have a prior conviction for violating a protection order under 2919-27 out of the Willoughby Municipal Court in case number 22 CRB 02392, dated November 1st of 2022. It was the same victim in that case, and that all of this occurring in Lake County, Ohio, and that would have been the state's evidence. Thank you.
Thank you. Ms. Novotny, anything to add to those facts?
No, Your Honor.
Mr. Hensley, did you hear what Ms. Cutts said? The facts would show if the case went to trial.
Wait, what'd you say?
Did you hear Ms. Cutts?
Yeah.
The case went to trial.
Yes.
Are those facts true?
Yeah.
What is your plea to violating a protection order, a felony 5?
Guilty.
Ms. Novotny?
Remember this document? Signed date. Today is 1/15/26. Your Honor, in open court, myself and my client signed the plea of guilty paperwork and passed it to the prosecutor to witness the same.
Your Honor, proceed the written plea of guilty and judgment entry. A witness for the defendant signed the document of the court. His counsel signed it and I signed it.
Mr. Hensley, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
Accept the written plea of guilty. Defendant was present. Ms. Novotny advised of all of its rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty.
Yes.
Finding it to be knowing, intelligent, and voluntary, I will accept his plea of guilty and find him guilty of violating a protection order of felony 5. I'm going to refer this for an updated pre-sentence report. Sentencing will be February 13 at 11 a.m. Ms. Novotny.
Your Honor, we would like the court to consider a bond modification, specifically if the court would be inclined to consider an own recognizance bond for Mr. Hensley. Mr. Hensley informs me that he would reside at 28439 Evergreen Drive in Willoughby Hills. He lives there with his mother, who is 92 years old, and he is the primary caregiver for her. Helps her with everyday functions and living, does housework for around her and maintenance. He also helps maintenance along with neighbors on his street that are elderly with regard to anything revolving the house. Your Honor, he also works, from my understanding, for Best Asphalt. He's been there on and off for 15 years. I know recently he's had some medical issues with intestine surgery. Previously in June 2025 he had it, in September of 2025 as well for a follow-up. And he is seeking medical attention as well. I know he's been having problems and complications for where that surgery has been occurred. Your Honor, we're just asking for any type of leniency when it comes to bond today.
Ms.
Thank
Cutts.
you.
Your Honor, when this agreement was made, there was no talk of changing bonds, so we were not anticipating a request for this. However, we do feel that it would be inappropriate. The defendant continued to call and violate this protection order for the entire day. He did admit when he was arrested by the police that he had been served with the protection order and that he knew he was not to be contacting her. He disregarded that in Willoughby Municipal Court. He was told that he was only to make phone calls to his lawyer from the jail. He has been making phone calls to other individuals as well, so he did not listen to what that judge said either. He does have a criminal history that includes 2 prior prison terms on 5 cases. All of those cases were before Your Honor, and he was sent to prison in 2021 for possession of drugs, 2 different cases, F5s, as well as an F5 theft in a 3rd case. And then he was sent back to prison in 2023 by this court on 2 different cases. One in this court, an F5 possession of drugs, and a Cuyahoga County F5 possession of drugs. He got out in 2024. Ms. Chinchar has indicated that there have been other protection orders that he has violated. We know that from his prior as well. So based on his history, how he handled this matter, we would ask that his bond at a minimum remain where it is, if not be increased or revoked.
All right, I'm going to revoke the bond. Anything else?
No, Your Honor.
Your Honor, the victim impact statement also be ordered.
So you do that on February 13th at 11.
Don't have a bond, don't get out of this?
Don't have a bond, no.
The others that others have, but from the plaintiff's perspective, the issues that we have are threefold, all related to depositions that have been noticed and the scheduling of those depositions. The first relates to a notice of deposition for a representative of defendant AECOM. That deposition was noticed in late December. Defendant's counsel indicated that it had some objections and asked for a meet and confer. We did do the meet and confer. As a result of the meet and confer, I attempted to address many, but not all of the issues raised by AECOM's counsel. I believe at that time we were still on an impasse at 9 of the 31 categories requested in that deposition notice. However, for the remainder, I did make some attempts based on our discussion to modify some of those. Amended notice of deposition was issued the following day. We received late yesterday new objections to the amended notice. I believe now the amended notice, by the way, eliminated a couple of categories, so there were 29 distinct topics.
Which 9 remained outstanding?
The 9 that remain outstanding are presently after the latest round of objections.
Well, before you tell me that, which 2 were eliminated from the original 31?
The 2 that were eliminated are all documents produced by AECOM, which was originally number 26. That's been eliminated entirely. And I'm sorry, I did a compare red line, so I'm looking at that. The last one originally was 31, which was AECOM's discovery responses. I eliminated those in their entirety.
Okay, so all but 9 have been agreed upon? Is that what you said earlier?
No, we were at an impasse at that point after the meet and confer, except with respect to 9 of those. After I revised and narrowed the scope of some of them, we are now at an impasse at apparently 12 of the 29 categories.
So you were at 9, you revised it, now you're at 12.
Well, to be fair, after the meet and confer, I revised them. He had to go back to his client to, consult with them.
Okay.
And after that, there were still some that they refused to produce witnesses on. So that's that initial issue.
Okay.
The second issue is I noticed a fact witness employee of defendant AECom, Vikram Gautam. He is a geotechnical engineer on the project based on discovery.
You say he was on the project. They say he was not on the project. He had nothing to do with the project.
Yeah, well, Your Honor, I didn't know what that until they produced documents that imply or suggest that in fact he was specifically consulted about the use of the shale fill material when it was being proposed. Now, I understand, based on our meet and confer, that his intention is to say that he doesn't remember that. Well, that's fine if that's his answer, but I believe I'm entitled to cross-examine him on that.
Okay.
So that's with respect to the project. He was also consulted later when AECom was investigating what the issue was. He was consulted at that time too. Again, the documents indicate that. So that's another issue I think I'm entitled to talk to him about. I believe I'm also entitled to talk to him about his general knowledge, understanding, experience, and expertise as a geotechnical engineer with respect to this use of this material in general.
If he was involved in the project?
Whether,
Or if one of those two factors, either when the problems arose initially, and you raised that to AECom, if he then reviewed things, so is it one of those two hooks that he would be able to talk about that in general? Or just
Correct.
as a guy who knows this stuff, or
That's
may or may
right.
not know? Okay, is one of those two hooks, right?
that's right, Your Honor.
Okay.
It's plaintiff's position that AECom sold this project to my client on using its vast knowledge and expertise in every specialty. And therefore, I think that we are entitled to explore, whether or not they did that. We know that actually they did, and what that knowledge and expertise was, and why they didn't use it in this case, apparently.
Okay.
So that is the second issue. The third issue is just the general order and scheduling of depositions. No one had noticed depositions in this case before I did so in December. I noticed those and requested that they be provided in a particular order based on plaintiff's strategy in this case. I believe I'm entitled to do that. Approximately a week later, defendant AECom issued its own deposition notices, which is fine. I don't object to any of those, including the 30B5 categories that they gave me, which are very similar to the ones they're objecting to in mine, but my clients don't have anything to hide. But given this dispute with respect to these two issues, I don't believe they should be able to take the depositions that they requested of mine because they manufactured a discovery dispute, so they could go first. I think it's common practice, and if everybody's being honest, if you notice depositions first, you get your witnesses first. That's just the way it goes. And so, until we can, agree on the depositions that I've asked to take, I don't think I should have to produce my witnesses. Now, I did offer to schedule them all, including mine, in the order that I requested off of the bat, and then deal with these discovery disputes. And if we could get them resolved, we'd have them calendared and scheduled. Nobody seemed to want to do that, and so we were apparently at an impasse on that issue. From the plaintiff's perspective, those are the three issues with respect to discovery.
But
Thank you, Your Honor. Dan Heyman for AECom. Addressing the three issues, start with the 30B notice, and we've presented, as requested by the court, our position in pretty good detail, generally into the specific requests. And I don't think it's accurate to say after we had our meet and confer, we were down to 9. We got a revised notice, and we did make some progress. Some there's agreed to be limited We got the revised notice, I believe, last Thursday. As I told Christine, we would review and get back to her. She unilaterally said, here's the revised notice, we're now down to 9. But in any event, I think we're at about 13. But as we've indicated, Judge, first of all, this is the first deposition they want to take. Okay, so of a 30B, there's been no depositions, which is going to require us to educate someone on this project before the benefit of any depositions, including our former employees. All our employees on this project that happened 8 years ago are no longer with us. So, it's likely, instead of being able to point to their deposition testimony, we're now going to have to schedule meetings, et cetera. And some of these, as you've seen, that just the sheer volume is impossible.
Hold on a minute. But, so you've indicated Stahl, Lachina, Wenzel, and Harvey, right?
I'm sorry, you're Stahl, Lanchina.
Stahl, Lanchina, Christy Wenzel, and Brad Harvey.
That's correct. There's been no, and they're no longer with the company.
Right.
And there's been no request yet for Wenzel or Hartman. But we have been in contact with Stahl and Lanchina. They work for other companies now. And as I explained to plaintiff's counsel last week, I can't in good conscience ask these people to call in and schedule time off of their current jobs on a tentative basis with no idea if this deposition's happening. We're prepared to present those people. But if plaintiff insists that we have to have a 30B5, assuming we can agree on some categories, that's going to take some time because we have an obligation to educate someone on this. And, there's been, our client alone, I think, produced almost 500,000 pages of documents. We're getting close to 1 million pages of documents in this case. We're talking about incredible breadth, especially what they've asked for, and putting aside just the ones that are incredibly broad with respect to this project. We have 3 or 4 of the 12 that are in dispute. I have 13, but 12 or 13 that are in dispute that want us to put up a witness who has global knowledge of all the projects that AECOM has done, global knowledge, with respect to certain issues. And so that's just, I don't know how you even begin to do that.
The issue relates to the fill, right?
Correct.
That's what we're talking about, the fill.
Correct. There's fill on every project, Judge.
I know that. So the issue in this case, the main issue seems to be the fill.
Correct.
The shale.
Correct.
Okay. So
but how are we about to, find out, from the scope of what they're asking for? It could be a project in California, it could be a project in Beijing, it could be, and how do we even begin?
Okay, let's quit playing around. Let's take out the list
Okay.
of 1 through 29 and go through it. What's the first one?
First one, Your Honor, is AECOM's knowledge, evaluation, and decision-making regarding the suitability, risks, recommendation, and use of pyritic shale spoil excavated from the Northeast Ohio Regional Sewer District project as engineered fill supporting interior building slabs of the YMCA School District and Senior Center.
Okay, go ahead.
We've agreed to produce a witness.
I'm
on
sorry,
that that involves this project.
I'm trying to find your latest objection.
No, let's go, I'm looking at the original list of 31.
Okay.
That's what I have in front of me.
Would you like, Your Honor, for me just to go over the ones that AECOM says they will not produce
Well, I'd like to
witnesses
see a
for?
copy of it, so I'm looking at it as you're, all I have is the original that was filed with these emails.
I think it would be helpful, Judge, if you had the amended notice.
Judge, I do have a clean copy of the amended.
Yeah, I do
Okay.
as well.
And do you have our responses? Would you like our
This
responses too?
This is our responses.
Okay.
So that's what Christine said is the amended and your responses?
Yeah, I
That's
have
correct, Your
the
Honor.
amended,
That's
yes,
the
yeah.
current status.
Okay. Thanks.
The court should have an electronic copy of this as well from our position that was submitted yesterday.
I did also, Your Honor, at Maria's request yesterday, provide her a redlined version so you can see how they were changed from the first notice to the amended notice, and I can give you that if you think it's useful.
All right, well, number one on the amended list, there's an agreement.
Correct. So I will move, Your Honor, to number 2,
Okay.
which there is, AECom has indicated in its latest objection that it cannot produce a witness. That is AECom's knowledge and experience nationwide and globally with projects using shale or shale-containing materials as engineered fill, regarding suitability risks, recommendations, and use of shale or shale-containing materials as engineered fill for the project where AECom has the noted knowledge and experience.
Okay.
And again, Your Honor, plaintiff's position is AECom regularly markets and sells itself as a global leader with expertise in all of these areas. And in fact,
So what is it you're looking for?
I'm looking to know what they know and understand about using shale fill material on construction projects.
Judge, if I can put a little perspective on this. Every building in Northeast Ohio's got shale in the fill. And if you look at the expert reports, it is a very detailed analysis, and we don't have to get into it now. But the notion that there's a green light, red light on shale fill is just nonsense. I mean, we'd all be living in tents in Ohio if that was the case. There's shale everywhere. So this is so broad. This, I don't know how many tens of thousands of projects, and how do we even begin to do that? And they're all different because they all have geotechnical.
Is it your position that shale shouldn't be used as the fill? And shouldn't have been used as the fill in this project?
That's right.
Okay. What does the contract say?
The contract has the specification for engineered fill does not permit the use of clay, which shale is specified as is classified.
So, do you have,
technical terms as
so I presume you're going to have an expert that says that this was the improper fill to be used to take out whatever was excavated.
Yes, Your Honor. And his expert says that, and everybody's expert says that.
Okay, so
That's not the issue. The issue is I believe I'm entitled to tell a story to the jury about why AECom, knowing and understanding, being the global leaders in construction that they are, decided to propose to my client to use this material that is plainly and commonly understood as to be improper underneath the building.
But it wasn't permitted to be used, is what you're saying, by contract and by all the experts, right?
That's right.
Okay,
Not our expert, Your Honor.
okay, well.
And but that is the issue. And so it has nothing to do with our global knowledge.
I know it's the issue.
It has nothing to do with our global knowledge. And they didn't, we may market ourselves that way, they didn't hire that services from us. We had no designer or engineer, we were the construction manager. They hired the architect, who, like every project, has a geotechnical engineer that they hired, who tested this specific material and told us it was okay. So is there an issue?
Or didn't test it and say it was okay, one or the other?
They absolutely tested it.
Okay, and they say you didn't test it.
No, we did it.
But anyway, see, we can sit here from now until the summertime when it's scheduled for trial and talk about this shit, but what I'm interested in knowing is getting the depositions done, because the expert reports were to be filed June 2nd, I think it was, okay? And and the remaining by September, now that's been moved, done. Fact discovery was done. But apparently,
Oh, Your Honor, I believe at the regional case management conference, due to this case, there was no fact discovery.
I know there was no,
Yeah.
I
Correct,
presume
that
I presume that
expert-
you wanted to do written discussion in advance of taking depositions.
That part was,
Okay, not positions. So let's try to get off the ground and stop discussing, I brought up the contract, so that, but I want to get the, so you think you should be able to have somebody who be that has knowledge of and all the representations they've made. They made the
they made it on their website, and they made
Okay.
it in the response to the
Okay.
request for proposal for this project, where they say, as a full-service
so
company.
so you believe that it's proved that they hold themselves out as action.
That's right, Your Honor.
Okay.
I have no idea.
Who do they produce for something? How about the president of ACOM?
The president of ACOM is not going to have knowledge of everything.
Okay.
Well, that's
I
what,
don't-
globally.
The
Listen,
United States.
Oh, great.
your point is they hold themselves construction, okay? And because shale was used, either pursuant to the contract, that's a bullshit claim that they made. Otherwise, all right, what's that really got to do with this? Isn't this a case of whether the use clay/shale, clay/shale? Isn't that the point?
Ultimately, but again, I think I'm entitled, and because I believe the facts are clear, including their geotechnical engineer that they consulted with. using this
Consulted with
material.
either during the project or after
During-
that Guyama or whatever, that guy.
I believe when I get to, they shouldn't have used this material. So, the jury's going to question, Your Honor, why did they do that? And I think I'm entitled to tell the full story. And part of that story is that they didn't bother to either use their expertise that they promised us that they would use, and that I think is part of the standard of care that is an express provision in their contract, to use their expertise.
The contract either calls for them, allows them to use shale clay or not use shale clay, right? The contract.
Your Honor, shale clay was not originally specified to be used. It came about as a change on the project due to the discovery of unsuitable soils during the site
Well,
work.
I mean, is it unusual to find unsuitable soils in site work?
It is not unusual, Your Honor, and therefore the contract included not the type of material to be used, but a unit price. So AECOM was only able to charge our client by contractual agreement before they knew that they had to bring in 10,000 plus cubic yards of this stuff, that they were only going to charge $25 a cubic yard. They were limited to that by contract. Their subcontractor apparently had this, and when it bid the project, bid very low for that unit price, which probably helped them win that contract. And so they had to use something that wasn't going to eat into their profit margins. And so they used this shale. And I want to tell the jury about how AECOM fully well knows that it shouldn't have been used, but they disregarded that because they just cared about making as much money as they could.
So it was not prohibited by the contract?
Your Honor, it was
Shale-
prohibited by the contract.
Okay. You told me the only restriction was the unit price of whatever had to be used as the fill.
No, Your Honor, the specifications have a general specification for the types of material that are acceptable and unacceptable by their general classification. By their general classification, the material is unacceptable. Nevertheless, the construction manager recommended it, and the architect and its geotechnical consultant approved it.
Okay, I'm not going to let you, 2 is out. 3.
Okay, 3 is AECOM's knowledge, expertise nationwide and globally regarding the known risks and consequences of using expansive material as engineered fill, including but not limited to AECOM's knowledge and experience regarding when unsuitable fill material must be sent or rejected or sent to a landfill.
Similar objection, Your Honor. I don't know how we even begin to present a witness on that.
Who hired ATC?
the architect TDA, we did not hold that contract. And by the way, ATC is the one who, in real time, when the decision was made about using this fill, tested it twice and reported the results. TDA reported to us that it was acceptable. But I don't want to get into all the merits like we've been going. I want to focus on this, Your Honor.
So do I, but I had that question because you keep saying we weren't the geotechnical engineer.
They didn't hire us for
on
geotechnical
the
service.
project.
Sorry, Your Honor, that's correct. And our contract expressly says we are not responsible for the architect's scope, which included the geotechnical engineer. So we may market ourselves that way, and we certainly have that capability because it's a big company, but they didn't hire us for that. They hired us for what's in our contract, which is to be the construction manager.
So whose job was it to provide the geotechnical engineer so that the specs could be drawn and the contract fulfilled?
I'm sorry, it was the architect hired the geotechnical engineer who, like any project, started with the geotechnical engineering report before design's even done, talks about what kind of fill can be used, et cetera. Then, of course, we get the specifications, which is what we're bound to. But none of that we didn't have anything to do with developing those specs. That was the design professional and their geotechnical engineer. Is there an issue of fact as to whether or not we met the spec? Yes, that's what this case is. It's that simple, Your Honor. And all this other stuff about telling our story wants to distract from what happened here and why.
So who was responsible for determining what fill went back in the hole?
Your Honor, the construction the entire construction and design team. So the construction manager was
Who had by contract, who had the approval? When decisions are to be made, such as this one, we're excavating however many cubic feet, what's going back in, whose job was it to approve or disapprove of that?
Your Honor, I believe it is both the architect's job and the construction manager's job.
That's what the contract says?
Yes, and the contract has a specific provision that says if the construction manager recommends a material or product that it warrants to the owner that that material is fit for the specific purpose.
Your Honor,
Your Honor, when there was a discussion about what fill to use, the architect did not propose shale or any other material. The construction manager proposed the shale material.
Okay. So going back to number one, that everybody agrees on.
correct.
Who's going to be produced for that?
I don't have a body here, but because it's limited to this project, we can educate someone. It's going to be someone who wasn't on the project, most likely, because there's none left. But we, as we can do and have an obligation to do under Rule 30b-5, we'll educate someone as best we can with the records. We'll try to put them in touch with the people who are on the project if we can, but they don't want.
As to the decision-making regarding the suitability?
It's all on the records, Judge, and we'll have someone that will have reviewed and educated themselves on the records.
Okay, so somebody will have reviewed the suitability and the risks and the recommendation of the use of the shale?
That's correct, Your Honor, the spec section is very clear, by the way, when you have unsuitable soils, the architect, in consultation.
I don't care about that, okay? You're going to produce somebody that answers her questions about the suitability of this shale being used as the fill, correct?
Everything in here, the knowledge, evaluation.
Right, I'm just focusing on the shale.
Yes, Your Honor.
Okay, and so there's somebody that kind of infers to me there's somebody within AECOM that looked at the suitability of shale. Okay? And so she's going to ask, well, what did you review? Who did you get this from? I got it from Joe Schmo.
That's correct.
She can go depose Joe Schmo.
You're correct. Which is actually a third-party defendant, GLC, who was our site contractor. But, Your Honor, I mean, we did object to this, although we'll produce a witness, just to make it clear. We didn't make the decision.
I thought we agreed on number one.
We didn't make the decision, but we'll have someone who can talk about everyone who did and all the records.
I thought we agreed on number one.
Correct, Your Honor.
Okay. Then what are you objecting to?
Well, I'm sorry. I thought you were asking who we were going to produce for number one.
I was asking that. Okay, but whoever you produce for number one, is going to be able to talk about the recommendation of and use of shale.
That was made by the architect, and it's.
I don't care who.
Okay, yes.
So
yes,
that's going to point her in a
Yeah,
direction that
yes.
it was Joe Schmo, okay? And then she can go and depose that person, right?
Yes, Your Honor.
So what's the problem with that?
No problem with number one, Your Honor.
I know there's no problem with number one, but as to, you want to talk about their knowledge of, in their representation, that they know all this stuff.
Yep.
And part of what you're going to find out is their recommendation and use of shale. And that's going to point you in a direction of somebody at ACOM or within ACOM or who ACOM consulted that says shale's good for this. So why isn't that enough? Why doesn't that give you the same thing you want by the worldwide investigation here?
I think, again, Your Honor, I mean, if you believe the interpretation of that is broad enough to encompass that, then I'm fine with that.
That's what I believe.
Okay. And we're in agreement that I can ask about those matters within
Well,
the
they've
scope of
already
number
agreed that
one.
you can ask about those matters.
Number one.
Right.
Correct, Your Honor.
Okay.
Not number two, which is out, and there's similar ones after it. We're not gonna have a witness who's gonna talk about our experience at every project that ever used shale.
I just said that. We just
Okay.
covered that.
Okay, well, I think Plaintiff's counsel said as long as I can do that on number one. I just want to be clear, Your Honor. Thank you.
Okay,
Okay.
Your Honor, so just to move this along, I'm gonna agree to remove 2, I'll remove 3. 5. Okay. Let's move on to a different issue. Number 6, AECOM's knowledge, understanding, compliance, performance, and breaches of the contract with the plaintiff for the project that is the subject of this lawsuit. AECOM has responded that it will only produce a witness who can authenticate the CM at-risk form executed by AECOM. And their knowledge and understanding of that is contained in the plain language. Somebody that says, yeah, this is the contract. But
That's
not
our-
talk about what they did, didn't do, should have done. And just by the way, Your Honor, they asked me almost the exact same question for my witness.
Which we discussed our meet and confer, and I said, if you want to narrow it, we will. I've asked for a meet and confer on their 30B5 because both parties have an obligation to conduct one, and I haven't had it yet.
I don't have any objections.
Okay, well, good, thank you.
I thought I said that at the
We'll
beginning.
expect dates then for those witnesses. Your Honor, knowledge and understanding is in this contract is thousands of pages. It's a construction contract. Compliance, performance, and breaches, again, are we going to put a witness who's going to talk about everything we did that's documented in 500,000 pages of records? Or are we going to focus on what's at issue, which is number one, which we've agreed to do? So it's not.
Well, part of what their complaint is when they brought the first heaving of concrete or cracking in the walls, they said, well, you guys are warranting this work, so come and look at it. And according to the plaintiff, you said, well, we don't know nothing about nothing. Everything's good.
Not accurate, Your Honor. There were years of the parties, and well after this project was done, well after punch list, where we were involved. Architect was driving that ship, by the way, which you would expect, because it's a geotech issue. But nonetheless, there were other specific categories in here with particularity, like what did you do to investigate, that we're agreeing. Warranty claims, we're agreeing. But this general, give us someone who can talk about everything you did on the contract and all our allegations of breach, is again just not within reasonable particularity required by the rules. It's basically the whole case. Put someone up who can testify about anything I want to ask on this case.
If it's limited to the issues in this case, I don't know why I wouldn't be able to ask about those things. And I don't know why you wouldn't be able to produce a witness to do that. We all know what the issues in the case are. I'm not going to ask about some obscure section of the contract that doesn't have anything to do with this case, of which there are many. I think we all know what the issues are.
So you're
in
talking
these.
about number 6 as it relates to the fill and building envelope issues?
Yes, Your Honor.
That's, yeah, number 1 is the fill, which we talked about. There are specific things, to your point on investigation, as we go through this, I can point to them. We agree to that. If you tell us particularly what you want, we have the ability to prepare a witness. To prepare a witness on anything about this contract, and certainly we're not going to prepare and present a witness who's going to interpret the written contract and give some kind of analysis, is overly broad, and it doesn't meet the rule requirements of particularity. Some of these others do, and we've agreed to present a witness. But this is a catch-all about anything I want to ask, they better be ready for it. How do I prepare a witness for that?
As it relates to the fill and the building envelope, right?
Yes, Your Honor, and I can add those words if it, but I
That would
just,
seem to satisfy Dan, wouldn't it?
Correct, Your Honor.
Okay.
and just to be clear, Your Honor, I do think I'm entitled to question them on their understanding of what particular parts of the contract pertinent to those issues mean.
Under what basis? I mean, it's a written contract. It says what it says. That's for the lawyers and the court to determine.
Your Honor, they act in accordance with what they understand the contract to mean, so I think I'm entitled to
So
ask.
give me an example of that.
I'm entitled to ask him what he thinks it means when they warrant that they're recommending a material, and what he thinks recommending a material means, because they're taking the position that they never recommended the material. Well, I'd like to know what their position is on that.
On whether they had an obligation to warrant the material?
Correct.
Or recommend
Because they
the material?
to recommend the material and the warranty associated with that recommendation.
Whether we recommend the material
As one example.
is an issue of fact, which we can keep going, is number
Well,
one.
so why can't she do fact discovery?
She's going to ask a lay witness whether or not you satisfied this warranty obligation, or doesn't this warranty, or give you a legal argument what the contract.
I think she just said she's going to ask whether it was your obligation to recommend or not recommend.
That's number one. We'll have a witness on that. But this, as written, number 6 is, you know, if we want to limit it to the fill and building envelope, that's okay. But to have a lay witness who's going to be interpreting contract provisions is not appropriate.
Well,
She could ask if we know or not we satisfied it, what we did. But that's what, I think she's made it clear what she wants to do.
I want to know what their understanding of that provision is, and others.
Well,
that
they
relate
either
to that.
had an obligation to recommend, or they didn't have an obligation to recommend, right?
Well, I don't know, Your Honor, about the obligation, but
Under the contract.
What the contract says is that if they recommend, then they must provide this warranty.
Okay.
Our position is, in fact, they recommended it, and they provided the
So
warranty.
your hope is to get somebody up there to interpret the contract and say, yeah, it was our obligation to recommend?
No, Your Honor, I want to ask them what they understood that provision to mean,
Okay, for what though?
because they're taking a specific interpretation of that. And so I want to know what the company's position is on that interpretation. I know what the lawyers say, I want to hear what the witness says.
That is the company's position.
What did you say?
Thanks, but I'd
What
like
the
to hear a
what the
witness
lawyer-
under oath cross-examined as to that position and not their lawyer.
So don't you want to find out from the fact witness whether ACOM recommended use of the shale? Isn't that the issue?
Yes, Your Honor.
So what difference where's the relevance of some guy saying, well, my understanding of this provision is that we were to recommend, or my understanding of this provision is we were not to recommend? What does it matter? The issue is whether they recommended or didn't recommend.
That's right, Your Honor, and there's a dispute about what recommending means. And so I think that I'm based on their understanding
Well,
of things.
it's
And
their-
so I want to know what their understanding is.
And their understanding is going to be what's written on the paper, Your Honor.
Well, that's what you say. He can say that,
Okay,
and
so
I can cross-examine
so who would this
him.
person be? Who you imagine this person would be?
Your Honor, I don't know. It could be one of I don't know how many people who worked on this project were responsible for this project.
I think
Or
you-
somebody who wasn't, and that they
I-
educate and give them that
I certainly think you
information.
can depose somebody who has, with regard to the contract, as with regard to the contract issue of the fill in the envelope, their testimony on whether they complied with the terms of the contract or not.
Okay, so is the only issue then the word understanding? I'll take that out.
And if you, well, again, Your Honor, performance of the contract and breach, I mean, that's so broad. I mean,
What,
how do I?
I'm gonna go out on a limb here and say, if you produce somebody to talk about whether ACOM complied with the terms of the contract as it relates to the fill and the building envelope, they're gonna say, of course we did.
Most likely, Your Honor.
Well, and then what are you gonna say? Well, are you,
Again, Your Honor, I've agreed that adding the word, limiting it to the issues in this case, which are the fill and the building envelope issue, is sufficient from my perspective. And further, I will eliminate the word understanding.
Your Honor, number 7.
They want to just say, yeah, this is the contract and nothing more. I don't think that's acceptable.
Your Honor, number 17 is any warranty claims for or relating to any water infiltration issues and floor slab issues for the project as the subject of this lawsuit would agree to produce a witness. When they describe in particularity factual issues that they want a person on, you agree to produce them. But these general, just to have someone talk about your performance under the contract is not the required reasonable particularity that the rules require. Same thing with the contract. They have number 18, AECOM's contractual warranty obligations for the project that's subject to lawsuit. We've agreed to produce. Okay, in the thousands, if not tens of thousands of pages of this contract, you now, with reasonable particularity, have told us what we have to prepare a witness on. We can do that. But these broad, just, catch-all, so I can play a gotcha game
okay,
with an unprepared witness aren't appropriate.
you have, of the 29, you have either 16 or 17 you've agreed to, right?
I believe that's correct.
You said 13 you don't, you said
That's
12.
correct.
I thought it was 12 when I counted.
Okay, so let's do it this way. Tell me the 12 you've agreed to.
Oh,
The
so it should be
17 that you've
we've
agreed to.
Sure. Here.
1, 4, 6, 7.
Well, I don't think 6, based on this
Well, we
objection.
say we had a qualifier, so, all right. So 8, 9, 10, 11, 12, 13, 15, 16, 17, 18, about 20,
Okay.
22, 23, 25. I believe that's it.
And you have one more that you thought was agreed to?
No, Your Honor, I had mismarked it on my copy. I think that what Mr. Haynes said is accurate.
Okay, so 2 and 3 are out.
I think I also agreed to remove something else.
I think 5 was another,
5.
one of the national and global.
Yep.
Okay, well, so let's go to 14. Are you talking about written communication?
Any.
Huh?
I'm talking about any communications, Your Honor. Now, I understand nobody's going to know every conversation that anybody have. That's why the standard is whatever is reasonably available. But they're obligated to go and find out what communications there were that go beyond the scope of the documents. And if there's nothing available, then there's nothing available.
Your Honor, I don't know how we determine all representations that were made on this project at this point, other than written, which are going to be thousands, most likely. I've seen enough of them. And, you know, former employees who were prepared to present, and they can talk about what representations they made. But again, the breadth of this, I don't believe meets the requirement of the rule of reasonable particularity. If there were certain representations that you could identify for us that we could educate someone on, because that's what we have to do. Because the people who worked on this are no longer with the company, we can do that, but I don't know where to begin on this. I mean, do we give them, you know, tens of thousands of emails that have been produced in this case? Start going through, and I mean, it's unworkable. It's not reasonable particularity is required under the rules, and it's unduly burdensome. You know, again, the rules, not only 30B, but civil rules in general, does require that you weigh that. And if there's other means that do not, you know, require us to go through all of this, where you can depose the people who are on the project, you can ask them about their written communications, you can ask about their oral communications. But if you want us to educate a 30B5 witness on something as broad as this, it's a Herculean task, and we don't think it meets the balance that the rules require with respect to undue burden.
So you know who was working on this thing for ACOM, right? Working on this project?
I believe I know some of them.
Well, there was 4, you read them at the beginning of the
Were
day.
those the only 4 people from ACOM that were in the capacity as the construction manager on this contract?
That's correct, Your Honor, and one of the third-party defendants, Green Space, had some individuals that were sub-consultant to us. And Plaintiff's counsel has asked for 2 of them, and we've said, yes, we'll produce those 2 former witnesses, or excuse me, former employees, who were the ones who were having these, as everybody knows from the records, these communications.
Okay, so you know you're going to depose those 4 people, I would assume.
I'm going to depose at least 2 of them presently. I haven't issued everybody who I'm going to depose, but Your Honor, I think the issue from our perspective is they're taking the position that is the owner's fault that this material went into the ground, among other things. And so I think I'm entitled to question a witness to get the company's knowledge of what you told the owner about this material.
The company knowledge is gone, Your Honor. We'll recreate it if we have to.
What do you mean the company knowledge is gone?
The employees who wrote the emails are no longer with us.
I know that. But
But we will educate someone.
who were those individuals?
John.
No. What was their position within?
John LaCagna was the project manager on South High School. This contract was for 3 schools. South High School is what we're here for. Dave Stahl was the project executive. Christy Wenzel, I believe, was an engineer who basically just is, documenting stuff. And the other person, I don't recall exactly, but the other 2 that they haven't asked for really were not that involved. The records show, but they're free to explore if they want with them.
Okay. So if, let's say that whoever the first guy is,
John LaCagna.
LaCagna says, yeah, I told Great Lakes Crushing to put that shitty shale in the ground. Does that not bind the company? Is that your position?
Oh, Your Honor, if they want to say that if they want to agree that all of Mr. Landocino's statements bind the company, that's acceptable to me.
And if that, why wouldn't Why wouldn't they bind the company
Well, I think, Your Honor,
as a construction?
as far as binding the company, the 30B5 deposition is, you're entitled to introduce it at trial as evidence, regardless of any witness availability. So that's what it is, which is why we have a lot of these things like legal understanding. This is a game of gotcha. Quite frankly, most of the stuff should be interrogatories or RFAs, but they're not, and they want us to put up a witness who's going to slip up and say, you know, yeah, we agree that's what that contract interpretation means, and say, we've now bound the company and we're going to read that to the jury. It's all fine and good, Your Honor, but we have the right to insist that they meet the rules, which is why the rule requires reasonable particularity, because of the uniqueness of a 30B5 and the obligation for us to prepare someone and the fact that it's admissible evidence. We have the right and opportunity, number one, to insist that they have reasonable particularity balanced with undue burden and hardship, especially when there's other ways to get this evidence. I mean, whether or not Mr. Lacchina binds the testimony, his testimony is what it is. He's going to either say the same thing at trial or they're going to impeach him. You know, so again, there needs to be reasonable particularity so we can produce a witness. Now, normally, Your Honor, we'd have fact depositions, and when our 30B5 occurred, and they said, we want the representations, we're going to say, our witness is going to say, read Mr. Lacchina's deposition, pages 50 to 80. But they want this to go first, fine, but that's going to put a burden on us, and we need reasonable particularity so we can produce someone else to say, good job.
All right, go to 19. Okay, so claims are made when things start going wrong. Is there a record of who at ACOM investigated any warranty claims?
There is, Your Honor.
Who's that?
It's primarily Mr. Lacchina and Mr. Stahl, and in conjunction with the Green Space construction management people. But again, this is you know, I believe I have the year right. The school was completed in 2019. These issues, at least formally, were presented to us, I think, in 2021. If I have, you know, almost 2 years after the building was open. Mr. Stahl, at least Mr. Stahl, I don't remember Mr. Lacchina, I believe he did too, re-engaged.
Were they gone at that point?
No, they were not, Your Honor. They left shortly thereafter. We responded. There's other provisions in here where they say all notices and response to notices. We said, fine, and we'll produce someone on that, you know. But the investigation was those two individuals who, of course, they can depose them. They left both left in early 2022. So at that point, it was basically lawyers. Green Space, I believe, still had someone who was involved. They were meeting regularly with the architect, with the school. The architect was doing a whole bunch of analysis. They were doing floor scans and all this stuff. This went on for years, basically, or at least 2 years, where the architect was driving that train and deciding what to do and they hired a consultant to do investigation, et cetera. So, you know, after 2022, when Mr. Lacchina and Mr. Stahl left, ACOP did have an individual who had nothing, when they requested a meeting, they had an individual who had nothing to do with the project and he would go out, but then it really became the lawyers and their experts, so it's really getting into, but again, it's not like we had an investigation over a weekend. It is an incredibly broad topic with incredible breadth that went on for years before this lawsuit was filed.
Okay, so do you know who investigated these warranty claims?
I know Mr. Lano Lakenia and Mr. Stahl was involved. I don't know, Mr. Gotham apparently, but I don't know beyond that. But again, Your Honor, I don't know why I wouldn't be able to ask about how they investigated the warranty claims that they breached. Because they, and if he wants to say only Mr. Stahl and Mr. Lanokina know, that's fine. But then he should agree that that their deposition testimony binds the company. And it's not overbroad, because if your position is that these are the only two guys that were involved, well, guess what? They can talk to whoever you want from the company, get their knowledge and understanding, and then testify on behalf of the company. It's not broad. That's what the case is about.
If Your Honor, if I may, if we were to do this like most of these proceed, and we had these categories, and we're going to take Mr. Lakinia's deposition, and this is very typical and usual, you'd say, okay, we're going to now do Mr. Lakinia's individual deposition, and we're going to now, but he's now going to be on categories 4 and 5. You can now depose him as a 30B5 witness. Well, they won't do that because they want us to have a 30B5 before we do Mr. Lakinia. Am I going to get Mr. Lakinia to sit for 2 depositions? I'll be, hard enough to get him to sit for 1, scheduling time off his job. So let's do them together if that's the case. It may very well that we can get him to be one of these, but we can't, if we want to insist on a 30B5 first, it's a problem. I mean, the 3 individuals that plaintiff said investigated, the 3 individuals that have asked for their deposition. We'll get to Mr. Godham in a minute, but we've agreed to produce them, but we have a clear understanding and ask the court's guidance for some of the various reasons we've talked about, global knowledge, et cetera. But they'll have the opportunity to depose those 3 people. But if they want a 30B5 on something this broad, it is going to take a long time to educate someone on that, rather than just ask the people who actually did it.
All right, 21. Isn't that the same? It's the same as 19, except for floor slab.
It's the same objection, Your Honor, but that's correct. It's basically, again, I'm talking about thousands of representations, probably.
All right, 24, go to 24.
Similar objection, Your Honor. We don't believe this is with reasonable particularity. They've got all whatever written internal communications there are, but again, we're talking about hundreds of thousands of emails that have been produced in this case. And this is a very broad word that makes it difficult, if not impossible, to prepare a 30B5 witness, as opposed to deposing the people who are actually writing the communications.
Your Honor, if I might, it seems like what Mr. Heyman is saying is that if there are individuals who are involved, then companies are not obligated to produce witnesses pursuant to 30B5 notices. If that is in fact the law, then please cite that to me so that I can, consider it, and I will, remove my thing. But that is absolutely not the law. There are individual fact witnesses and there are corporate representatives. Only corporate representatives bind the company. Again, if he wants to take the position that those individuals are their corporate representatives, that's fine. He can pick whoever he wants. It seems to me that relieving the burden that he's talking about is to use those people as his representative. Then he should just do that. He can pick whoever he wants, whether they work there or don't work there. It doesn't matter.
Even if I pick a Mr. Lakinia or Mr. Stahl, or probably some of these categories would be several people, they're going to be our 30B5. Now I got to have them prepared for more than just what they know. Fine. We have not taken the position that they're not entitled to take a 30B5. We have taken the position that they got to meet the rule requirement that you specify with reasonable particularity so we can produce a witness. I think we've already seen, Judge, this 30B5, the way, with the scope that they're envisioning, is gonna take a week. I mean, there is undue burden and hardship to be balanced where you cannot say, produce a 30B5 witness to answer anything I wanna ask in this case. That's not the rule. And that's what they're trying to do with all of these broad categories. And as you see, just so they're sure, they just keep repeating a lot of them in different forms, so that in essence they have us educate a witness who can talk about anything to do with the case. That's not a proper 30B5 purpose.
All right, so you have, they're on 26 through 29 that are in dispute, correct?
Correct, Your Honor.
Okay. So I'll consider those that are still in dispute and rule on those. Okay, now what about this,
Thank you, Your Honor.
this guy that, this Gautam, what about Gautam?
We've agreed to produce him, Your Honor, for deposition. As I told plaintiff's counsel, I believe he's going to say, I have no recollection of ever working on this project or discussing with them during the project. That's fine if they want to do that. You know, there's about 6 in the sea of thousands. There's, I don't know, 5 or 6 emails where they're trying to schedule a meeting with him. But that's it. There's no record that it ever occurred or that he ever did it. But nonetheless, that's fine. They can depose him on that. But they've made it clear in their submissions to the court, but what they want to do is turn him into a geotechnical expert and start asking him all of his opinions about geotechnical items with respect to shale fill, which is irrelevant to whether or not we met the spec. And they're trying to turn him into a expert witness who's not been designated as such. And they know, because I've been out there with Christine and Mr. Gautam on at least 2 occasions, that after the lawsuit was filed, we as attorneys have used him as a consulting expert, which is absolutely privileged under the rules of the work product. So, you know, we will not let him testify to any of that privileged material. But if they want to take his deposition and hear him say, you know, and who knows, and maybe they'll throw something from him or he'll recall something, but to say that he doesn't have any recollection work on the project, we'll produce some. But we're not going to let them get expert opinions out of him, which again are not relevant to whether or not we met the specification. We were not the geotechnical engineer on this project.
Your Honor, I don't intend to depose him to seek his opinion. I want to know what he knows about this type of material and its use in similar applications.
How is
Why-
that?
I'm not even going to take the position that what he says is true or not.
But
But I want to know.
so what does it matter what he thinks? What does it matter what he thinks is shale in these kind of projects? He either had some input on it or he didn't.
Yeah, Your Honor, I think one of the reasons why it is very relevant is because, again, if they have institutional knowledge of these things, they represent and market themselves as bringing that institutional knowledge to all of their products, and in this specific case, made that representation to the client. It matters, and it matters because there's a consequential damages waiver in this contract, except if they acted with gross negligence or willful misconduct. And so if they're talking to a guy who knows something about this material and why it shouldn't be used, and he either didn't tell them or told them something that was accurate or told them something inaccurate, and they proceeded to use all of that stuff anyway, it goes to the issue of their gross negligence and willful misconduct.
Okay. Well, I guess what you're going to have to do is tell me when you do your deposition at Gautam, okay? And I'll sit at my desk and stare at my phone and wait for it to ring.
Okay.
Okay?
I don't intend, Your Honor, to ask him anything about work he's done, the Thompson Hine firm, anything he's communicated with them, or anything they've communicated with the dozens of in-house counsel they have on this case.
I'm just, I'm struggling to find out how, what he says other than as it relates to this project is relevant. But you can ask it, you can object, and then you can call me when you can't agree.
Thank you, Your Honor.
Okay, what about this ordering and scheduling? The first attempt to schedule depositions was December, mid-December?
Yes, Your Honor.
I guess the first question is, why is that?
Your Honor, from the plaintiff's perspective, it was a large and substantial task for everyone to gather and produce the extraordinarily large quantity of documents in this case.
Okay.
It was a very big task for the parties to, or at least again speaking from the plaintiff's perspective, to get their experts' reports completed. And then, Your Honor, at least the plaintiff spent a substantial amount of time preparing for the mediation, which
I bet that went over like a lead balloon between the parties, right?
not even,
It was not successful, Your Honor. And
It sounds like it was a disaster.
yes.
What did it last, like
it's
5 minutes?
It's always a
No.
disaster if it's not successful, Your Honor.
You know, well, sometimes it's
It was
successful
2
and
days.
that parties narrow some issues and get closer together so that it can work eventually.
It was 2 days. And if I could just speak to that, couple of issues. Document production has been an issue, and we've been trying to work with Plaintiffs' Counsel on that with their production for a long time now. We had 40,000, I think, additional emails from the YMCA produced in November, right before the mediation. I think just this week, based on our meeting first to try to get the school district, because there's some glaring deficiencies, we got another roughly 30,000. So that's not been done. I've also been trying to get verified interrogatory responses on things as simple as itemized damages, which we don't have yet. But I do believe that the mediation, we didn't get the expert report until June. We didn't get the building envelope expert report until September. The parties did spend, I think, substantial time selecting a mediator during 2025 and scheduling it. I think we had our first call with him in August. There was a lot of meetings, and at the very first meeting with the mediator, there was a discussion about what do we need to do to get this case ready for a meaningful mediation. And there was a discussion about, do we do a bunch of depositions, or do we do things like get some expert reports in the mediation setting, because they're not due yet, but we still don't have the third-party defendant expert reports, so that we can do that. So all the parties, I think, did focus on the mediation, at least the latter part, once the plaintiff's expert reports were in September on that process. So I do think that that was a conscious decision that I can't speak for everyone, but that the parties collectively made was the best use of our time at that point.
I agree.
Okay. So besides your 30B5 and the individual, how many other individuals do you anticipate deposing?
Your Honor, thus far I have noticed, I believe, 3 individuals, 2 former AECOM employees. I believe the project manager for Great Lakes Crushing, which was the site contractor that brought in and used the fill, as well as the 30B5 of Great Lakes Crushing. Quite frankly, I was waiting to see what information I got there and where else that was going to point me. Mr. Heyman has requested a deposition of Jeff Henderson from TDA.
So you've indicated about 6 different people right now, right?
Presently, yes, that I have noticed.
Okay. Dan?
I believe we've asked for 8, and I've actually, because the party's not here, ATC's not in the case, but I've reached out to their counsel and asked for one of their employees. And quite frankly, Your Honor, I mean, mine include their experts, which is another issue I think that not just me but other parties want to discuss is the case schedule. And if we have a February report deadline, a March 1 summary judgment deadline, which we currently have, is why I asked for their experts. If there's a change to that, I mean, the experts can obviously wait. But those are the ones that I
So
determined are essential,
9 or so?
that I would like to have at least before dispositive motions due. There's going to be a few more. I mean, I think the other parties, there'll probably be another dozen at least, I would think. Any other parties have feelings on that?
George?
Well,
You've been very patient.
Presenting the architect TDA, Mr. Heyman has noticed the deposition of main architect of TDA on this project. Christine did not notice any. So what TDA intends to do for depositions would really depend upon what's going on with plaintiff and AECom. But I mean, we produced an expert on behalf of TDA. ATC is not in the case, but is in communication with ATC. Dan wants to take somebody from ATC. That's the yeah. So there's this, those are the procedural issues that I think you should.
When am I getting a response on the
Plaintiff is going to object to that, and I intend to file that by the opposition deadline date of Tuesday. What they're asking for
seated?
Thank you, Your Honor. We are here on the matter of the State of Ohio versus James Maxey, case number 25 CR 000468. We are set today for a change of plea hearing. The defendant is present in open court with their attorney, Nicolette Tomazik. It's my understanding that the defendant will be pleading to count 1 and count 2 of the indictment. Count 1 being tampering with evidence of felony of the 3rd degree, count 2 being possession of cocaine. There's no agreement regarding sentencing. The state would request a pre-sentence report and drug and alcohol assessment prior to sentencing.
Ms. Tomazik?
Yes, thank you, Your Honor. That is my understanding of what's going to happen today. I did speak with Mr. Maxey, and that is how he would like to proceed today. Thank you.
Mr. Maxey, how old are you?
52, Your Honor.
How far did you go through school?
11th grade.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
PTSD, depression.
Are you being treated for either of those right now?
No, just through therapy.
What therapy do you have?
Signature Health.
Do either of those conditions affect your ability to understand what's going on here?
No.
Did you get a copy of this indictment?
Yes.
And you're pleading guilty to both charges, is that correct?
Correct.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, then let me know. If you want to talk to Ms. Tomazik some more, let me know that, and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to these charges?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
In count one, tampering with evidence is a felony of the third degree. It carries a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes.
Count two, possession of cocaine. It's a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification, you're voluntarily giving up those things listed. Do you understand that?
Yes.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 48 months and a maximum fine of $12,500. Do you understand that?
Yes.
Are you on post-release control to the parole authority?
No.
You understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years.
Yes.
You understand your felony conviction will prevent you from owning or possessing a firearm.
Yes.
You understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority.
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months with the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 48 months. Do you understand that?
Yes.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Ms. Tomaszek before pleading guilty today?
Yes.
Has she discussed everything about your case and answered all of your questions?
Yep.
Are you satisfied with the advice she has given you?
Yes, I am.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, I am.
Do you have any questions?
No, I don't.
All right, Mr. Knopf, if the case went to trial, what would the evidence show?
Your Honor, had the case proceeded, the trial, the state would have shown that on or about the 28th day of March 2025 in Lake County, Ohio. The defendant was walking down the street in Painesville when Painesville Police Department identified the defendant as someone having an active warrant through Menor. Painesville Police pulled up next to the defendant, turned on their overhead lights, and yelled, "James." The defendant stuck his hand in his pocket, went around a vehicle out of sight of Painesville Police, and dropped a dropped a crack rock on the ground, confirmed by the Lake County Crime Lab.
All right, Ms. Tomaszek, anything to add to those facts?
Nothing on the facts, Your Honor.
Mr. Maxey, did you hear what Mr. Knopf said, that the facts would show if the case went to trial?
Yes.
Are those facts true?
Yes.
What is your plea to count 1, tampering with evidence of felony 3?
Guilty.
What is your plea to count 2, possession of cocaine, a felony 5?
Guilty.
And what is your plea to the forfeiture specification on count 2?
Guilty.
Ms. Tomaszek?
Your Honor, I had an opportunity to review the written plea of guilty with Mr. Max before coming to the court, and he's prepared to sign. Your Honor, for the record, Mr. Max and myself have signed the written plea of guilty.
And Your Honor, for the record, I have witnessed the defendant and defense counsel sign the written plea of guilty. I have now signed it myself, and with your permission, I'll return to the bench.
Okay. Mr. Maxey, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present. Ms. Tomaszek advised of all of his rights, being a knowing, intelligent, voluntary waiver. He understands the nature of the charge, a consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept his plea of guilty and find him guilty of count 1, tampering with evidence of felony 3, and count 2, possession of cocaine, a felony 5, and the forfeiture specification. I'll refer this for a pre-sentence report and a drug and alcohol evaluation. Sentencing will be May 13 at 11 a.m. Ms. Tomaszek?
Yes, thank you, Your Honor. We did want to talk about Mr. Maxey's bond if the court would allow it. Mr. Maxey's bond was revoked last year around in June of 2025 for failing to appear for his pretrial. Your Honor, since then he has been in the Lake County Jail. He is currently serving a sentence through the Painesville Municipal Court. He is in jail treatment program right now. He is set to get released from that on April 14th. Your Honor, he's really enjoying jail treatment program. He said it's been extremely beneficial for him. He's been working with one of the counselors through JTP. His name is Dave, to get into Signature Health for outpatient. He also does have a great support system. His boss has been sober for over 40 years. Mr. Maxey's also willing to wear a GPS monitor if the court would allow his bond to get reinstated. Your Honor, Mr. Maxey would just like to try to continue on with this sobriety. As indicated, JTP has been very beneficial for him, and he would like to try to continue on, get into Signature Health, and get the process started of continuing on his treatment. Thank you.
What's the sentence for that he's serving?
It's an M1, possession of, or, I got a needle.
Okay. Your Honor, is a misdemeanor of the first degree drug paraphernalia. He had a needle on him, I believe, with some drug paraphernalia in it.
All right, Mr. Knopf.
Your Honor, the state would be opposed to reinstating bond. The defendant failed to appear at the last hearing. That's why the bond was revoked. But in addition to that, the defendant has multiple failures to appear on his record and multiple contempt of courts. And the whole reason why he was stopped in this case was because he had a warrant for menor mutiny.
This, you were arraigned on this case May 16th of last year. There was a pretrial scheduled May 22nd that you didn't, or I'm sorry, June 3rd. You didn't show up for it. Why didn't you show up for it?
My boss's truck had broke down. I did call and talk to the public defender's office and asked them multiple times what I could do. But to be honest, Your Honor, I was terrified. I've never had a felony before. I've never come to this court before. I didn't know what to do, and I had signed away my way right to a speedy trial, and I was terrified. I don't even have a better answer for you.
Well, Mr. Knopf indicates that you've failed to appear several times before in other courts. Why is that?
The one that he was speaking about, the menor one, it was all I had to pay a fine, and it was the first, or right after I was due to me to pay it.
Well, it seems like there's other, besides the menor one, there's other failures to appear.
Yes, to be honest, I was a drug addict.
Okay, well, you are a drug addict. So,
Correct.
So why would I let you out if you don't like to show up?
I'm changing everything in my life. This has been the first time in my life that I've addressed the trauma and everything that I've dealt with as a kid that I didn't know was underlying the issues. I have been involved with AA and that before, but the dual diagnosis part is huge for me. In the last 5 years, I've lost my whole family. I've lost my mom, my brother, my sister. For the first time, this is all hitting home to me. I haven't seen my kids in years. My daughter I have a grandson. Like, this is all changed to me. I don't know how else to explain it. I want to be a different man.
Well, then you should be. You should stop thinking about it and stop talking about it and start doing it. I'm going to change the drug and alcohol evaluation to a psychological evaluation. All right. How long is your sentence? I know you get out on the 14th, but how long was the sentence altogether?
It was 60 days.
Okay. What's the most time you ever spent in jail before at one time?
60 days.
This sentence?
Yes.
Or did you have another one like that?
Yes, I had another 60-day one.
Okay. When was that?
4 years ago.
Okay. When you failed to show at the pretrial in June, the offer was a plea to attempted tampering, a felony 4 and a felony 5, which Mr. Knopf was still willing to offer this morning, and I said, no, I won't accept that. You understand that?
Yes, I do.
Okay. Because you can't decide when you're going to show up and when you're not going to show up.
I understand that.
Okay. Well, I hope you understand that, because I'm going to reinstate your bond to what it was before. And I can guarantee you right now, if you don't show up or if you screw around out there, then you're going to go to prison for 48 months. And prison for 48 months is a hell of a lot longer than Lake County Jail for 60 days. You understand that?
Yes, I do.
Anything else, Mr. Knopf?
No, Your Honor, thank you.
Ms. Tomazik?
No, Your Honor, thank you.
All right.
All rise.
This says read only. Can you check mine?
Check.
All right.
modification. The City of Kirtland feels that a preliminary injunction would be inappropriate at this time based upon the request that City of Kirtland follow the law as the injunctive remedy. And given my reading of the rules, it is not necessarily clear to me exactly what the timeline would be to brief that, and I thought it would be best for the parties to come together and ask exactly what the remedy is, given that we are still in the process of seeking administrative approval on the applications of the co-defendants.
Okay, so let me give you my understanding of where things are at. Mr. Zeman's client, Mr. Lonkar, correct?
Yes, sir.
Is seeking to build, what, 5 condo units?
5 duplexes, Your Honor.
Okay. Side by side?
Yes, sir.
I assume? Right. In a historic district, which, in the historic district in Kirtland, is that right?
I believe that's their overlay, correct, Your Honor?
Okay. And in order to, right now, I think, from what I understand, and correct me if I'm wrong, that residential is not permitted in that district?
Conditional use for what this
Okay.
residential development is, correct?
So your client went before the BZA to get a frontage variance, is that right?
2 components, correct. It's basically a bowling alley lot currently. There's frontage on 306, and there's a structure on that. It's the back acreage that's to be subdivided. And since the subdivided rear parcel won't have any frontage, the purpose of the variance was to permit that lot split.
Okay. So did BZA approve what your guy requested?
Yes, Your Honor.
Okay. There were some notice issues brought up by Mr. Walter as to the various TCE entities. Are the members all the same in the TCE entities?
Yes, Your Honor.
Okay. So then I think it goes before the Planning and Zoning Commission for the lot split issue. Is that right, Joe?
Well, the Planning Commission would issue the conditional use permit for the residential development. The variance was granted, I believe, by the Board of Zoning Appeals.
Okay. For is also as to the split?
To create a non-conforming lot, correct.
Okay. So was the conditional use permit approved by Planning and Zoning?
Yes, it was approved, subject to final development plan, and so that has not come before the City Council yet.
Okay. Has the plan been submitted? Who does the plan get submitted to? Planning and Zoning first?
Correct. And the BZA, I don't know if the BZA had a look at it or not, frankly, but initially the Planning Commission takes a look at it.
Okay, and they haven't approved that yet?
The Planning Commission did approve it. Correct.
Okay.
But I believe, and I don't want to speak for the City of Kirtland, they view that as a preliminary approval,
Right.
not a final approval yet.
Okay. So, and it's not gone before council yet?
Correct, that's the next step in the process.
And it's your position that none of that matters until council approves what had been done by their commission?
Correct. There is no, while the conditional use has been preliminarily or conditionally granted by PCC, it has not been issued, and therefore there has been no harm yet that's befallen the plaintiffs, if ever.
And can it be issued without council approving it?
No.
So where are we at with regard to whether we are here too early?
Well, Your Honor, with all due respect, the lot split and the variance were granted without any ability of my client to contest that.
Okay.
And if you look at the section that's in our preliminary injunctive motion at page 4, the Kirtland Code of Ordinances 1275-04 specifically states that a conditional use permits, there's 3 issues we have. First, the variance. We never had a chance to object or go after that.
And is that because only one of the entities got notice?
That was none of our entities got notice.
Well, there were a number of times it was continued or delayed, right?
Those were other hearings. Those were on the conditional use permit. They were on the lot split. They were on, the variance did get continued once, but we still didn't, according to the verified complaint, still did not get notice of that. And so the variance was never given, my clients were never given the opportunity to come and contest that. And the case that we cite, which is at El Hassan.
Hold on, was notice provided to any one of the TCE entities?
Yes, it's our position that it was, and it was continued once the plaintiffs made us aware that notice was not provided.
On the issue of the frontage and the split?
Correct, Your Honor.
Okay, go ahead, Mr. Walter.
Sure, and so the case that we cited was El Hassan, ALIHASSAN versus Alliance Board of Zoning Appeals. While it is a 5th district, it's pretty on point that if you don't have the ability to contest certain issues, then the administrative procedures don't really apply. And our position is from the variance to the lot split, and then we now have a conditional use permit that we did appear at. My involvement didn't start in this until January. And to the city's credit, I'm now getting emails as to when the hearings are from their assistant law director. We weren't able to contest any of that. And so this lawsuit was filed because the groundwork of that, which was the variance, is the capstone of everything else that goes forward. And so the way that the variance ordinances are written in the city of Kirtland, there were some difficulties that had to be proven, and there was absolutely nothing put on the record. We would have opposed the granting of the variance, which would have stopped this project in its steps. And that's...
If Kirtland goes ahead and puts that on their agenda to approve what BZA and what planning and zoning did, and they have a meeting and your client's there and objects to it based on he never got notice of the BZA actions, which they contest, but if they then approve it, then do you have an avenue to challenge that?
We would be able to challenge that, but again, the procedural irregularity was the granting of the variance, which we never had the ability to.
I understand what your argument is, okay? I'm questioning whether we should be here until such time, because there is no variance granted, right?
The variance was granted.
Well, I guess we're speaking two different languages. Nothing is effective until council approves it, right?
No, the site plan is what is pending, not the variance. The variance has already been granted.
Does council have to approve variances by the BZA?
No, so the variance that would allow a lot to not have frontage was approved.
Okay.
Then the lot split happened, that was also approved. However, in order for my co-defendants to actually build and use that property as they suggest, it needs to go through the full conditional use and site plan development process, which culminates with city council approving the site plan.
What's the value to Mr. Lonkar of the variances by the BZA if the lot split or if the plan is not approved by council?
Well, in regard to the lot split, that's what's allowing for the residential development. That's our purchase agreement. In terms of the conditional use permit, I mean, there's no project without the CUP.
Okay. So does he have the ability to utilize what the BZA's approval without a plan approval by council?
No, the lot split would just allow for a non-conforming lot. There's an easement agreement, of course, allowing for ingress and egress through the remainder parcel to 306, but it's just vacant land at that point without an approved site development plan.
Okay. And Mr. Mitchell, your client sold to Mr. Lonkar the property?
My wife.
Right. Who's your client, right?
Yes, and she's in the hospital right now.
Okay. So we've got your motion for judgment on the pleadings, essentially saying that it really isn't ripe yet because what Kirtland hasn't taken action on the plan approval, right?
That's the large gist of it, Your Honor. There are a couple other arguments, including that two of the landowner defendants are inappropriate as they're outside of the notice requirement. So even if they didn't receive notice, they were never supposed to receive notice.
Okay, what is the notice requirement?
I will get them confused in a moment, Your Honor, but one is 300 feet, one is 500 feet, and they're outside of the 500-foot limit.
And Joe, do you know the specifics on the 3 versus 5?
Actually, no, Your Honor, not off the top of my head.
What of that, Eric?
I believe the conditional use permit is 300 and the variance is 5, but I could be wrong, Your Honor.
Okay. And you have not responded to that yet?
No, Your Honor.
Okay. And when is your response due?
We filed a motion yesterday for a short leave based upon I was in trial last week, or 2 weeks ago, and catching up.
Okay.
We just filed that.
Okay.
Otherwise, it would be due, I believe, Thursday. But we asked for a short leave.
Okay.
And Your Honor, we have no problem briefing that and then letting the court rule going forward. I think the judgment on the pleadings plays heavily into the injunctive relief as well. And then there's Mr. Mitchell's motion to stay, which, we didn't oppose that, Your Honor. We've opposed his motion for dismissal or more definite statement. Because you're right, there are a flurry of motions pending. There's the motion to dismiss and motion for more definite statement by the Mitchells, the motion to stay by the Mitchells, and the motion for judgment on the pleadings by the city, and then our motion for preliminary injunction.
Okay. What was your motion to stay, Mr. Mitchell? Remind me.
Well, it was in hope that you would rule before we had to do substantially more work.
Okay. Well, I think my inclination is to rule on your motion, okay, before we do anything else, because your injunction and declaration is simply that you're asking that I make Kirtland follow their ordinances, right?
Which started, you're correct, Your
Right.
Honor, which started with the granting of a variance
Right.
that
Okay.
should not be the capstone of this.
So I don't think they're opposed to following their ordinances.
Well, they haven't been so far, is our
Well,
contention.
that's why we're here, okay? Because you say one thing and she says another, and these guys are caught in the middle. So what I'm going to do is I'll look at your request to extend your time to respond to that. Did you guys, Mr. Mitchell, are you intending to respond to the motion for judgment on the pleadings?
No.
Joe, what about you?
Oh, there.
Okay, so I'll wait for your response. I'll give you a chance to reply, and then I'll rule on that, and we'll go from there, because that seems to be the first block here before we do anything else. Does anybody disagree with that?
I do not, Your Honor.
No, but if I may, Your Honor.
Yeah.
Plaintiff has asked until June 11th. It is very likely that the city council hearing on the site plan will happen before then.
When is it scheduled for?
It is not, I don't think that it is actually on the schedule yet, but it could be as early as next week.
Can you grab the law director?
I can, but I can tell you that the PZC issued a resolution sending it to City Council last night, so in terms of when City Council puts it on the agenda, I will find out, but I'm happy to go get him.
Okay. How are you enjoying your less hectic life?
Well, it's getting there, Judge. I keep telling I'm trying to work like part-time, 20 hours a week, and I'm still putting in 40 hours. So.
With them still? With Menor still, or are you done with them?
Oh, I
You're
was,
done.
March 20th was my last day there, so 23 years was sufficient.
Yeah.
More than sufficient.
Morning, Judge.
Mr. Lalo, we were just talking about the timing of council's action on the plan.
Yes.
Do you know?
So they met last night, planning and zoning met last night, and it's my understanding that they passed that resolution, which then refers the final development plan to council per our zoning ordinances. That'll be in the form of a resolution, and they'll have an opportunity to review it. I believe it'll be on Monday night.
Next Monday.
Correct. Then it's up to them as to whether they want to approve it, have modifications, or deny it. They can have it go for 3 readings, or they can waive the 3 readings as well.
What's their practice in a situation like this? What's their practice to waive or have all 3?
So I'm trying to remember, the only other case we had which was similar to this was the Coca property. about 5 years ago, and I believe they actually called a special meeting to consider that approval and waived the 3 readings. I could be wrong. I don't recall that off the top of my mind. But the waiving of the 3 readings, it's hit or miss as to how they wish to proceed with it. So they don't always waive the 3 readings. Sometimes they let them go 2 or 3 readings. I can't predict that.
Okay. All right, well, they're gonna do what they're gonna do. I'm not gonna suggest they do something or not do something. I'll just rule on what's in front of me and we'll go from there. If they approve it, then we'll see where that puts us. But I'll rule on your motion for the extension of time, and
Thank you, Your Honor.
and we'll go from there. So you don't need, nobody needs to respond on the injunction. So let's just hold everything.
We've already responded,
Okay.
I believe, on the injunction.
Okay. All right.
And we would request that you roll on our motion at the same time.
The motion to stay?
No, not the
Or what?
motion
The
to
motion
stay,
for
the
more
motion to
definite?
dismiss.
Okay.
Because it's our position that we're in this just nominally, and there's no actionable, or there's no cause of
Yeah,
action
where do
expressed
they-
against us.
Where does Mr. Mitchell's client fit?
They were the property owners, Your Honor.
Okay, I know, but are they, you're challenging the process by which you got here with
Right.
Kirtland, right?
And the purchase agreement is conditioned upon all of the approvals, and it can be withdrawn at any time after, if all the approvals are not obtained.
What I expressed in one of those documents is what's really going on here is Mr. Christopher, Mr. Walter's client, has sought to buy our property since at least 2002. And the reason he didn't buy it is he didn't want to pay a fair and marketable price. And he wanted to add on to his party center by putting tree houses and or RV parking in for his weddings and stuff like that. And that's all that's going on here. It's a made-up case on the part of the plaintiffs.
I would bet Mr. Christopher has a different take on it, but you know, that's
He
why,
might, but it wouldn't be accurate.
that's why we have courts.
Right.
So I'll take, is everything in? Did you respond?
Yes,
to
Your
his
Honor.
motion? Okay.
Yeah, the motion to dismiss is fully briefed.
Okay. All right, so I'll take those up and we'll go from there. Anything else? Anybody else?
No, Your Honor.
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
I'm sorry? So much.
And that's where we will end it for today. Ladies and gentlemen, thank you for watching and participating. So I'm going to call this a day. Tomorrow is Judge Mertz. Tomorrow is Judge George Mertz. Is that his real name? Is it George Mertz? What? I have a list of, yeah, Judge George Mertz. So I'm going to go ahead and call this one for today. I thank everybody for watching and participating. For now, ta-ta and ciao-ciao. You all have a wonderful, wonderful evening, and I'll catch you on the next live stream.